right, members of the jury, I'm about to read you your final instructions. Is there anyone who needs a break before I begin to read the final instructions? Okay, I see no hands. You could pass those out, please. Each of you are going to have a copy. You'll have these back in the deliberation room when you deliberate, so you can read along with me or listen to me, whatever you choose. Once everybody has a copy, I'll begin. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I'm about to give you. Donald Hartung, the defendant in this case, has been accused of the crime of first-degree murder, 3 counts. First-degree murder includes the lesser crimes of second-degree murder and manslaughter, all of which are unlawful. A killing that is excusable or was committed by the use of justifiable deadly force is lawful. If you find Voncile Smith, John Smith, and/or Richard Smith were killed by Donald Hartung, you will then consider the circumstances surrounding the killing in deciding if the killing was first-degree murder or second-degree murder or manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. I now instruct you on the circumstances that must be proved before the defendant may be found guilty of first-degree murder or any lesser included crime. Murder, first degree. To prove the crime of first-degree premeditated murder, the state must prove the following 3 elements beyond a reasonable doubt. 1, Voncile Smith is dead. That's for count 1. John Smith is dead. That's count 2. Richard Smith is dead. Count 3. 2, the deaths were caused by the criminal act of Donald Hartung. 3, there was a premeditated killing of Voncile Smith for count 1, John Smith for count 2, and Richard Smith for count 3. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which he is accused, there may be evidence that he committed other acts that would constitute a lesser included crime. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you would next need to decide if the defendant is guilty of any lesser included crime. The lesser included crimes indicated in the definition of first-degree murder are second-degree murder, manslaughter. To prove the crime of second-degree murder, the state must prove the following 3 elements beyond a reasonable doubt. 1, Voncile Smith is dead, John Smith is dead, Richard Smith is dead, for each respective count. The death was caused by the criminal act of Donald Hartung. 2. And 3, there was an unlawful killing of Voncile Smith for count 1, John Smith count 2, Richard Smith count 3, by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that, 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2, is done from ill will, hatred, spite, or an evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. If you find that the defendant committed second-degree murder, And you also find beyond a reasonable doubt that during the commission of the crime he personally used, carried, or displayed a weapon, you should find him guilty of second-degree murder with a weapon. A weapon is legally defined to mean any object that could be used to cause death or inflict serious bodily harm. If you find that the defendant committed second-degree murder, but you are not convinced beyond a reasonable doubt that he personally used, carried, or displayed a weapon, then you should find him guilty only of second-degree murder. Manslaughter. To prove the crime of manslaughter, the state must prove the following two elements beyond a reasonable doubt. 1, Voncile Smith is dead on count 1. John Smith is dead on count 2. Richard Smith is dead on count 3. And 2, Donald Hartung intentionally committed an act or acts that caused the death of Voncile Smith for count 1, John Smith count 2, Richard Smith count 3. Or the death of Voncile Smith count 1, John Smith count 2, Richard Smith count 3 was caused by the culpable negligence of Donald Hartung. Every person has a duty to act reasonably toward others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed you. The explanations of justifiable homicide and excusable homicide are in Instructions 7.1, Introduction to Homicide. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. I will now define culpable negligence for you. As I have said, every person has a duty to act reasonably toward others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care toward others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard of human life or of the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to consequences, or which shows wantonness or recklessness or a grossly careless disregard for the safety and welfare of the public, or such an indifference to the rights of others as is equivalent to an intentional violation of such rights. The negligent act or omission must have been committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that defendant must have known or reasonably should have known was likely to cause death or great bodily injury. If you find that the defendant committed manslaughter, and you also find beyond a reasonable doubt that during the commission of the crime he personally used, carried, or displayed a weapon, you should find him guilty of manslaughter with a weapon. A weapon is legally defined to mean any object that could be used to cause death or inflict serious bodily harm. If you find that the defendant committed manslaughter, but you are not convinced beyond a reasonable doubt that he personally used, carried, or displayed a weapon, then you should find him guilty only of manslaughter. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the indictment through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial, and to it alone, that you should look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are, did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Does the witness's testimony agree with the other testimony and other evidence in the case? Has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Has the witness been convicted of felony or misdemeanor involving dishonesty or false statement? Whether the state has met its burden of proof does not depend upon the number of witnesses it is called or upon the number of exhibits it is offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. Law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. You must consider the testimony of some witnesses with more caution than others. For example, a witness who hopes to gain more favorable treatment in his or her own case may have a reason to make a false statement in order to strike a good bargain with the state. This is particularly true when there is no other evidence tending to agree with what the witness says about the defendant. So while a witness of that kind may be entirely truthful when testifying, you should consider his or her testimony with more caution than the testimony of other witnesses. However, if the testimony of such a witness convinces you beyond a reasonable doubt of the defendant's guilt, or the other evidence in the case does so, then you should find the defendant guilty. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove his innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by his decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. A statement claimed to have been made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including but not limited to, 1, whether when the defendant made the statement he had been threatened in order to get him to make it, and 2, whether anyone had promised him anything in order to get him to make it. If you conclude the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. There are some general rules that will apply to your discussion during deliberation. You must follow these rules in order to return a lawful verdict. You must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. This case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits in evidence and these instructions. This case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision. in this case. Your duty is to determine if the defendant has been proven guilty or not in accord with the law. Whatever verdict you render must be unanimous, that is, each juror must agree to the same verdict. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. You may find the defendant guilty as charged in the indictment or guilty of such lesser included crime as the evidence may justify, or not guilty. If you return a verdict of guilty, it should be for the highest offense that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. The verdict must be unanimous, that is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charge. The verdict must be in writing, and for your convenience, the necessary verdict form has been prepared for you. You don't have it with you, but you'll have it in the jury room, and I'll briefly go over how it appears. It'll be entitled Verdict, and you will have, as to count 1, Voncile Smith, we the jury find the defendant Donald Hartung. You'll have a blank for guilty of first-degree murder as charged in the indictment. You'll then have a blank for guilty of second-degree murder, a lesser included offense. Then you'll have a question: during the course of committing second-degree murder, did the defendant personally use, carry, or display a weapon? And then you have a blank for yes or no. Then you have a blank for guilty of manslaughter, a lesser included offense. Then a question: during the course of committing manslaughter, did the defendant personally use, carry, or display a weapon? And blanks for yes or no. Then a blank for not guilty. And as to counts 2 and count 3, count 2 for John Smith and 3 for Richard Smith, you'll have the same options on those counts. A separate crime is charged for in each count of the indictment. Although they have been tried together, each crime and the evidence applicable to it must be considered separately, and a separate verdict returned as to each. A finding of guilty or not guilty as to one crime must not affect your verdict as to the other crimes charged. In just a few moments, you'll be taken to the jury room by the court deputy. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It's also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict, and to bring the verdict form back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberation should stop until the juror returns. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as a blog, Twitter, email, text, message, or any other means. Do not contact anyone to assist you during deliberations. These communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I've given in this case, you must tell me by giving a note to the court deputy. If you need to communicate with me, send a note through the court deputy. If you have voted, do not disclose the actual vote in the note. If you have a question, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions, if I can, in writing or orally here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. The exhibits will be sent into the jury room with you when you begin to deliberate. I think there's a couple of exhibits, such as the bullet and bullet coating, which are in envelopes, clear envelopes. Just look at them through the envelopes. Don't open the actual envelope, that evidence. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply in this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules we all share. Any objection to the instructions as read?
Not from the state, Judge.
Judge, the only thing is, can you explain to the jury how they might view the electronic media that was introduced?
Yes, you should have a computer back there where you'll be able to play any disc or such that you have. If you have any difficulty getting that to operate, send a note to the deputy and we'll get that straightened out for you. All right, members of the jury, in every case there are alternate jurors selected. In a case as significant as this, there are typically 3 or more alternate jurors selected. The alternate juror's role is just as important as any other juror in this case, but the alternate jurors do not deliberate unless one of the other jurors becomes ill or otherwise can't proceed. In this case, the alternate jurors are with our sincere thanks and appreciation, you are excused at this time.
Judge, may we?
Yes. All right, let me correct that somewhat. The alternate jurors will not participate at this stage of the deliberation. They may be needed later on in this proceeding, but the clerk's office will notify you whether you'll be needed or not in the next days. The alternate jurors are to continue to not have any contact with any information regarding this case, just like you have during these past 2 weeks, until you are notified by the clerk or this proceeding ends. Do not read anything about the case, don't research, don't view any information, and don't speak to anyone about the case. So you're not free yet to talk with your family members about the case. You will at some point, but we're not there yet. So the 3 alternate jurors, and correct me if I'm wrong, are free to go home for the day and go to your work, go about your lives, but you can't speak to anyone about the case or have any contact with information about this case, and you will be notified in the next several days regarding your need for any further proceedings in this case. Are there any questions by the alternate jurors? About your lunch? You're going to have a lunch. You get your lunch, but you're going to have your lunch separately from the other jurors. But you'll be given your lunch. It's hopefully not too cold. Any other questions from the alternate jurors? Okay. So again, with our thanks and appreciation, you are released for today. You will be notified about your further status, and your lunches will be given to you by the deputy. In just a few moments, as soon as they have cleared their belongings and such out of the jury room, you'll be allowed to retire and begin your deliberations. When you reach a verdict, let the deputy know, but don't tell the deputy what your verdict is. And as soon as I'm advised by the deputy that it's cleared, you'll be allowed to begin your deliberations. Y'all can be seated. Consider your verdict. All right, anything else to address before we go into recess?
Nothing to say.
All right, we'll be in recess until we hear from the jury.
All right.